Hello, dear friends. Now we enter in a general explanation of church and state relations in modern Europe. Relations between church and state determine the scope of religious freedom and equality, primarily of religious groups and secondarily of their followers. Church-state relations in contemporary Europe range from systems characterized by institutional unity of the state with one or more priests to systems characterized by institutional separation of the state from many creeds. The first type of system is subject to many variations, while the second can be divided into several subsystems. Systems of institutional separation, however, generally prevail. In this fourth lecture, I explain the systems of church and state relations existing in the states of modern Europe. In contemporary Europe, there are two systems of church and state relations. First system is that of institutional unity or state religion. And the second system is that of institutional separation between state and church. And when I speak about church, I mean also religious communities or communities of non-believers. The majority of the European states today have the system of institutional separation between church and state. And a few only states in Europe have the system of institutional unity or state religion. The system of state religion has many variations. And the system of separation can be divided into several subsystems. Characteristics common to all systems. Common characteristics shared by all systems of church-state relations include the public practice of religion, except in certain countries, is not an exclusive right of state churches, recognized communities, or registered religious communities, by virtue of special laws relating to creeds or of general statutes concerning private corporations. The European countries have not, like the United States, second characteristic, the European countries have not, like the United States, devised a legal definition of religion compatible with international standards. As a result, they generally inadequately protect the freedom of new creeds. Which are the common characteristics of all the systems of church-state relation. First characteristic, the public practice of a religion or belief is not limited to the churches or religious communities which have institutional characteristics, that is, which are states, recognized or registered according to special laws relating to religions or general statutes concerning religions. But there are some countries which prohibit the public practice of religion if a religion is not a registered one. Such a country is Belarusia. But according to the international standards on religious human rights, a state cannot impose registering to religions, to exercise publicly their religious beliefs. Because religions have the right to select for registering or not. Registering means to acquire legal personality according to the state law. Second common characteristic to all systems in Europe, as already I have explained in my previous lectures, is that in Europe there has not been elaborated any legal definition of religion as in the United States. Now I come to the systems of institutional unity or state religions. System of institutional unity inherently do not ensure equality between religious communities They do, however, guarantee the autonomy of non-state creeds. The systems of state church do not assure an absolute equality between religious communities. And as I have explained already in the third lecture, a state church is in conformity with religious freedom and religious equality if the state does not discriminate against other religious communities. That is, if the state does not limit its privileges to the other religious communities. Because as it concerns religious human rights, the state is obliged to respect the enjoyment of religious human rights by any group which pretends, which says that it's a religious one. The religious equality primarily is connected with religious privileges, that is, religious rights given by states beyond the religious human rights recognized by the international law or constitutional law. In church-state systems, the right to religious autonomy is limited for the state church because the church, state church, accepts this limitation for the period for which it is a state church. If it ceases, if it stops being a state church, then this religion acquires again the full extent of its freedom to autonomy. Freedom to autonomy means that a religious community has the right to enact, that is, to legislate for its internal affairs in the context of respecting public order and public morals. This means that the state is not permitted to legislate for the internal affairs of the churches or religious communities. Either in the system of state church, or in the system of separation. When I speak about the state church, I mean that the free churches or religious communities, that is, the churches or religious communities which are not state-run, continue to have the full extent of their right to autonomy. It has to be noted that the affairs of the religious communities are of three types: internal, external, or mixed one. According to the standards of religious human rights, constitutional and international, formulated in the context of the contemporary contemporarily legal culture. As it concerns the internal affairs, only the religion is competent to legislate for them through its legislative bodies. As it concerns the external affairs of religions, only the state is competent, it has jurisdiction to legislate for them. An example of an external affair is the regulation of the forms of the legal personalities for religious communities. As an example of internal affairs of religious communities are the religious organization, religious administration, the designation of religious leaders or religious ministers, etc. As it concerns the mixed affairs, in other cases, in other states, there is a cooperation between a state and some religions for regulating of the mixed affairs. In other states, a state is the only competent, it has jurisdiction to regulate the mixed affairs. Mixed affairs constitute the religious agency in the military or prisons, the religious instruction in public schools, etc. When there is a cooperation in some states with the states, and some religions, this cooperation is effectuated through legal agreements, which then are approved by the legislative bodies of the state and church concerned. For example, for the regulation of the religious agency in the army, if we take the example of the military dioceses of the Catholic Church in different countries, for example, in Italy, Spain, we see that an international agreement is stipulated between Holy See, which has international public personality, and the respective country, for example, Italy, Spain. For regulating this subject. And in this international agreement, the papal law, that is the Apostolic Constitution, Spirituali Militum Curae, concerning the statutes of any military diocese, is accepted by the respective country, and the Holy See accepts the regulation by the states of the military topics of the military bishop and military priests. Now, after these parentheses concerning the different types of affairs of churches or religious communities, I again return to the system of state church, which during the time in which it retains this property of state religion, state church, it has a limited extent of the right to autonomy. But the other church or religious communities which are free in a state which has a state religion have the full extent of their right to autonomy. In Greece, which has the system of state church, the full extent of the right to autonomy now is protected by the law 4301 of 2014. For the organizational structure of religious communities and their associations. And this is valid for the churches or religious communities which have private law status. But as it concerns the religious communities which have whose organizations have public law status, as Muslims in Thrace, or Jewish or Israelite communities, the right to autonomy of those religious communities has not been fully implemented, but it is limited only to auto-administration, despite the fact that the right to autonomy of non-state religions does not depend on the public or private law status. The church or religious communities which are not private, which are not state churches, are private or public law persons, but sui generis because of the right to autonomy incorporated in religious liberty according to the constitutions of states, and for the states which have not expressly recognized the right to autonomy in their constitutions, this is done by the European Court of Human Rights. In the case Orthodox Church of Bessarabia against Moldavia, in which European Court of Human Rights says that the right to autonomy results from religious liberty. Norway, which has the system of state church for each evangelical Lutheran church, institutionally protects not only of the church or religious community, but also of the communities of non-believers. In Denmark, which has the state church system for each evangelical Lutheran church, has the procedure for recognition of religions, which is connected with the legal, with the attachment of legal consequences to religious marriages. Greece, except the now existing law, which regulates forms of legal personality for religious communities, there is the law of 1939 for the concession of an administrative license for building or functioning for temple or a house of prayers for non-Orthodox religious communities. United Kingdom accepts a theistic definition of religion. United Kingdom, not United Nations. United Kingdom has a state church, that is, the Anglican Church is the state church, and the United Kingdom accepts, as I said already, a theistic definition of religion But the theistic definition of religion discriminates against the religions which are non-theistic. 1. Finland, Sweden, United Kingdom offers legislative guarantees of a relative ecclesiastical autonomy for their own churches. Now we have to stop this fourth lecture because time passes, and we'll continue in the next fifth lecture on Erasmus Ecclesiastical Law. Thank you for your attention.